Couple of administrative things. So next Monday, next Monday, I'm going to be at a conference, so I won't be able to have office hours. However, I am going to be available as usual on next Tuesday, so please come by. I will be available for coffee, so for those of you who are signed up for coffee on Monday, by all means, please still come by. There's a conference at 3 o'clock where I will be speaking. Professor Guo can give you the details. I'm not sure. It's some sort of capital markets conference. So you'll see me talking about U.S. securities regulation. If you're interested, that will be at 3 o'clock, which is why I won't be able to join office hours. Also, 2 weeks from now, April 30th, I know you're going to be terribly unhappy about this. Class is canceled, I guess, right? You're going to be on holiday, getting a suntan. You know, I will tell you, these readings are really good on the beach. Okay, if you have nothing else to read, please be sure to bring them. But I guess the class on the 30th is canceled. Okay, so we started with Moran last week. That is our poison pill case, you may recall. And Moran involved a flip-over poison pill. Not a flip-in, but a flip-over pill. And recall, a flip-over pill means that rather than receiving diluted stock in the target company, you receive diluted stock if you're a shareholder of the target in the finally combined, newly merged entity. Right? So the idea is to dilute not simply the target shareholders and the acquirer, but potentially to dilute the acquirer's shareholders after the merger takes place, after the acquisition is completed. So we began to look at poison pills, and one of the questions I asked, remember, particularly in the context of the flip-in pill, where you are trying to dilute the acquirer after the trigger, 15 or 20%, rights are issued, they become irrevocable, they entitle the shareholders, everyone but the acquirer, to buy stock at a discounted basis. I asked, why doesn't the poison pill raise Blasius concerns? Right, we recognized it doesn't raise issues regarding the all holders rule, the concern over the tender offer rules, because there is no tender offer. Right, so we don't need to worry about the federal tender offer rules. Unlike the Unical self-tender, which today would not be possible because of the all holders rule, we don't have to worry about its application to the poison pill. But why not Blasius? Why don't we have a Blasius issue? I know you stayed up at nights worrying over this, 3, 4 in the morning, wrestling with this issue. Why isn't there a Blasius concern? Blasius, remember, involved a structure where the board of directors, in response to a hostile acquirer, someone who was looking to take over the company, they stacked the board of directors. Right? They expanded the board to 15. They had 7 directors. They expanded the board to 15, added 2 more, so that no one could take control over this company until, at some future date perhaps, because it was a staggered board, you could begin to elect a new group of directors. And so the whole purpose, remember in Blasius, was to limit the ability of anyone, not just this acquirer, but any shareholder, basically devaluing the ability of any shareholders or even all of the shareholders to change control over the board. And where the primary motivation, as in Blasius, was to entrench the board, to block the ability of shareholders to vote out the existing board, to limit the franchise, the value of each share's ability to vote for, take control over the board of directors, the court said there had to be a compelling justification. So why not here? Why not in the case of the poison pill? Because remember, in the case of our flip-in pill, after you trigger 15, 20, 30%, whatever the trigger amount is, it means that the shares that are issued by the target firm at a discount to everybody but the acquirer will effectively dilute the acquirer. It might have had 20% of the company, but now it will have a substantially lower percentage because of the newly issued shares. Other stockholders will obtain these shares. The newly issued shares that dilute the interest of the acquirer since the acquirer under the poison pill doesn't have the benefit of getting this discounted stock. So why not a Blasius problem? I thought I had 20% of the company. I thought I had 20% of the vote. Now I only have, 15%, 12%. I have much less than what I thought I had. It's blocked my ability, lowered my ability, not blocked, lowered it, limited it, diluted it. Why not a Blasius problem? Anybody? Well, let me ask you, in Blasius, what triggers the standard of review in Blasius? What does the board of directors need to do? What is their primary motivation? To entrench themselves. Now, arguably, that's going on with the poison pill, but entrench themselves in a special way. Right? If we're concerned about entrenchment, we look at the Unical standard. Right? The poison pill looks at the Unical standard. But what's special about Blasius? They're entrenching themselves. It's kind of like a game show. When I ask you the question, if you get the answer right, this music plays in the background. What do you think? What's the particular? It's affecting the franchise, right? Blasius goes to affect. They say, look, the way in which we expect shareholders to monitor, to oversee the board of directors, they could always sell the stock if they don't like the company, but the way in which they have a clear method of controlling, not any one shareholder necessarily, but the shareholders as a group, is through the franchise, and the board of directors shouldn't be primarily motivated to get in the way of the franchise, to block the ability of shareholders to be able to vote them out, to control the way in which the board of directors operates. So it's the franchise. In this instance, in this particular case, if the pill gets exercised, it means that yes, because of the additional shares that are issued, I may have a lower voting right. But in advance of the pill being exercised, are your voting rights influenced under the poison pill? Let's assume for a moment I engage in a proxy fight. I don't buy stock, right? So the trigger is going to be 20%, let's say, in my poison pill. I don't buy stock. Instead, I engage in a proxy fight. I get votes. So a proxy fight, you'll recall, is going out and soliciting votes. I want your vote. We're going to vote against the existing board of directors. And I end up with votes for 51% of the shares. Does that trigger the pill? Right? The pill is triggered not by votes, but by stock ownership, or by a tender offer for stock ownership. In fact, it's relatively easy, if you can solicit votes, to get around the poison pill. So how would you get around the pill if I did my proxy fight? How would you get around this? So let's assume we don't like this board of directors. I'm a hostile acquirer. I know that if I break 20%, the poison pill is going to be exercised. I don't want that. That hurts me. It hurts the other shareholders. I want to try to avoid this. What's the way for me to get around the poison pill? Okay, I go to the shareholders and I say, look, this is a really good deal I'm offering you. You should go ahead and support my efforts to get rid of the board of directors and change the management. So give me your vote as part of the proxy fight, or if there is no shareholders meeting, perhaps I'll do it as part of a consent solicitation, much more difficult. But give me your vote as part of the proxy fight, and we'll get rid of the board of directors. So has the poison pill in any way influenced the vote in this case? Not at all. In fact, through the exercise of the vote, I can get rid of the board of directors, and what's going to happen? I'll put in a new board, and what will they do? Redeem the poison pill. Remember, right? Only after the trigger level has been passed, 15, 20, 30%, whatever the level is, at that point, the rights, the ability of shareholders to receive discounted stock, at that point it becomes irrevocable. Right? The board can't get the rights back. But prior to the trigger, if I'm below 20%, you can simply redeem the pill. It means typically you will give some maybe nominal amount, 1 cent, 10 cents to the rights holders in order to redeem the rights they've received. But you can cancel the pill. After you've broken the trigger point, at that point the rights are irrevocable. You're stuck at that stage with dealing with shareholders that may exercise their rights, buy stock at a discounted level, but prior to the exercise, I am able to use my voting rights. So the proxy process is not affected at all. The poison pill still enables me to use my votes. And the court says that's sufficient. Right? So when the court is looking at the nature of the pill and whether it gets in the way of the proxy process, it says, notwithstanding the fact that there might be some effect once you break 20%, because the voting rights themselves are not affected prior to the trigger event, and because it's relatively straightforward, if in fact you are an acquirer with a good price that shareholders should support, it should be relatively straightforward for you to get proxies, perhaps do a tender offer conditioned upon the poison pill being removed. So you're going to say, I'll buy your stock, but only upon first the poison pill being removed. You can get around the limitation on voting rights, the potential dilution on voting rights through the normal proxy process. So there is potentially a dilution, but because of the ability through the proxy process prior to the exercise of the pill, you're able to, through board elections, and perhaps through conditioning your tender offer on redemption of the poison pill, get around its potentially dilutive effect. And the courts say that's sufficient, right? That's not going to, we don't view that as being preclusive. We don't view that as being such an overwhelming effect on voting rights as to raise a Blasius concern. What if you were to have a pill that was triggered on voting rights? Not simply ownership of stock, not simply a tender offer for stock, but a proxy fight. Does that raise Blasius issues? Probably, right? You don't see that coming up. But because of the court's analysis on why the traditional pill doesn't raise Blasius concerns, if you were to tie this now to voting rights, more likely it raises a Blasius concern. Okay, is there a hostile offer happening in Moran? Do they actually have a hostile deal? Is there a T. Boone Pickens knocking on the door? A Ronald Perlman knocking on the door? No. So what analysis? What analysis? What's the standard of review here for the court in looking at the board's adoption of the poison pill? What's the standard of review? Is it business judgment? So remember, so we've got the business judgment rule. First of all, the business judgment rule. Who has the burden? Plaintiffs. Okay. In this instance, what has the board done? It's adopted a poison pill. Do you get the business judgment presumption when you adopt a poison pill? Why though? Why? So the director is going to have to show. So we're going to see a shifting burden of proof. The burden will now be on the board. And what's the standard? What do we call this? Intermediate business judgment, sometimes called the Unical standard. Why? Why do we have this shift in presumption?
Because the basis of business judgment rule is not since the law is facing and takeover and then administration.
Okay, so normally when we're looking at the business judgment presumption, it's based on the idea that the board of directors in the ordinary course will act in a manner consistent with their fiduciary obligations. They will maximize value. In this case, is there anything in the record to suggest that the board is doing anything wrong? Why this heightened standard? There's nothing in the record to suggest the board isn't doing anything beyond thinking what's in the best interest of the company. In fact, when the court looks at the board's analysis, it seems to support it. So there's nothing to suggest a problem. Why not just give them business judgment? I'm sorry? Inside? What kind of a conflict? Okay.
Directors will lose their control power.
Okay, they may lose their authority, right? But there's nothing to suggest that they actually will lose it. There's nothing in the record to say that the board actually did anything wrong. Why not just give them business judgment? Board seems to have asked all the right questions. Why impose the burden on the board of directors?
But they're facing financial takeover.
Right?
Yeah.
So they're facing a potential takeover. There are two magic words I'm looking for. Sorry? Mixed motives? No, that's Bob Clark. That's way back. We passed Dean Clark. The omnipresent specter. Do you remember that? In the Unical case, they're not looking at whether or not there's an actual conflict. They're not looking at whether or not the board really did something wrong or really was concerned about losing their jobs. This board may not have cared. Maybe they said, it's time for me to take a vacation. I don't care. The point is that there's now a conflict that raises the specter, the potential for the board of directors to act in a manner inconsistent with their obligations to the shareholders. And because of that risk, because of the particular circumstances, the conflict that they face, we're not going to begin with the presumption in their favor. The court will adopt a heightened standard. The burden of proof is on the board of directors, and they have to demonstrate that they meet this higher standard of scrutiny, this Unical standard. So it's not based upon an actual conflict, or whether the board is really worried about losing their jobs. They may not care. We don't know. The court says it's not able to assess what the directors are thinking, whether or not they are in fact conflicted, but this omnipresent specter, right? This potential for a conflict means that the benefit, the presumption in their favor shouldn't apply. There should be a heightened standard of review. The burden should be on the board first to demonstrate that they are entitled to business judgment. If the board can demonstrate it meets the Unical standard, then the court says, fine, the burden shifts to the plaintiff. We will give you the benefit of the business judgment rule. Okay, so with that, what is the Unical standard? What do you have to show? If you're the board of directors, does the board make does the court decide there's a threat?
No, the board.
The board does, right? It's process. Remember, the courts aren't really good. And they recognize this, right? They are not the best people to make judgments about value, about whether or not there is in fact a good business deal. Courts, however, are really good at assessing the process. Okay, so they look at the process here by which the board saw that there was a threat. So the question is the board acting in good faith? Are they acting reasonably, consistent with their duty of care? Are they asking the right questions? Right? And based upon this analysis, this duty of care, asking the right questions, do they have a basis in order to assess a threat? What kind of a threat? Okay, threat to the shareholders or threat to the corporate policies and the effectiveness of the company. So basically, is it a threat to the shareholders, right? Threat to the shareholders we saw in Unical. That was T. Boone Pickens. Two-tier coercive tender offer that places the shareholders in an extreme position of disadvantage. Or it is a threat to the corporate policy, the way in which the company is run, its effectiveness, its ability to continue to operate. So a threat to the company or a threat to the shareholders. After inquiry, good faith, reasonable diligence. Again, it's focused on the process by which the board has concluded that there is a threat that they need to respond to. Okay, and then what? What's the second part? Sorry? Reasonable response. Before the reasonable response. So there's going to have to be a response. Has to be within a range of reason. Right? A reasonable response. And the response is really dictated by the nature of the threat. Big threat, big response. Smaller threat, smaller response. So whether or not the response, given the nature of the threat, is reasonable is where the court ultimately will look. But before it decides whether or not it is a reasonable response, what can it never be? It can never be draconian, coercive or preclusive. Yes, right? Can never be draconian. Coercive or preclusive. What do these words mean? What does coercive and preclusive mean? Coercive or preclusive? My handwriting is horrendous. Okay. What does coercive mean?
Force the shareholders to choose an alternative that is different to yours.
Yeah, so coercive is, you're coercing the shareholders. Right? You're forcing the shareholders to take an alternative to this particular offer in a way that the shareholders have no choice. But it has to be an alternative. It's not simply saying we're going to continue to do what we've been doing. Right? We thought we had a good plan. We will continue with our long-term strategy. We're just not changing. Right? That's not an alternative. They're talking about a different deal, an alternative deal that gets forced upon the shareholders that they have no ability to respond to. They cannot judge which deal to accept, this second deal or the original threatening deal. So it cannot be coercive. You can't coerce the shareholders. What's preclusive?
Block the others from taking the acquirer over.
Okay, so preclusive means blocking, right? We're blocking, precluding the ability of anybody to acquire the company. Right? So Blasius was in fact preclusive. Right? After Blasius expanded the board from 7 to 15, increased the number of directors from 7 to 9, nobody could take control of the company at that stage. The board had put into place a process, because it was a staggered board, so that no one could take control of the company, in addition to being a Blasius problem requiring compelling justification. It was also preclusive. Right? It blocked anyone else from acquiring the company. Okay, so in this case, Moran, what's the threat? Is there a threat? Is T. Boone Pickens knocking on the door? No. So what's the threat? Possible. Okay, right? So Moran had suggested an LBO. The board was nervous about this. They were aware of the fact that guys like T. Boone Pickens were roaming around, so that there were coercive offers, that acquirers were buying companies and busting them up. And so they said, look, we don't want to wait until someone shows up before we adopt our poison pill. We wish to do it now, in advance, so that a hostile acquirer, someone who will be a threat, knows that they are dealing with a board of directors that will act in a defensive manner. So the threat is not an actual threat in this case. It is a prospective threat. And the court finds that they are reasonable, right? They've done an investigation. They've made an inquiry in determining that, yes, in fact, these sorts of deals are happening. These sorts of hostile actions are taking place. And they're benefited by what? What's the analysis here is benefited by what aspect, what characteristic of the board? Right, we saw this in Unical as well. It's not dispositive, right? It's not a final solution. It's not something that is black and white in favor of the board, but it's something the courts take real notice of in deciding the reasonableness, the good faith basis upon which they, in this case, assess a threat. Independent, right? A majority of the board is independent. And because a majority of the board is independent, again, it's not dispositive, but they say, look, this is an important consideration that we will take into account in deciding whether or not there was a good faith, reasonable basis to determine there being a threat. Okay, no allegations of bad faith. It looks as if in the Moran case we have the potential for a threat. The first part of the Unical test is met. And we know the response can't be draconian, can't be preclusive or coercive. And in this case, the court notes the pill is not going to be preclusive for the reasons that we don't have a Blasius problem. Exact same reasons. Right? It's not a preclusive pill because at the end of the day, even though it makes it more expensive for an acquirer to try to take control of the company, it's not impossible to get around. You can trip the pill and actually have to pay more money, but it doesn't block you from doing the takeover. But even before you trip the pill, even before it's exercised, you have the ability through a proxy fight to go out and remove the board of directors and ask the new directors to to get rid of the poison pill itself. And you might also just simply, if you do a tender offer, condition the tender offer on the poison pill being removed. So there are ways around the pill, right? There are ways around the pill either through the voting process or through the terms of the tender offer itself. It might make it more expensive. It might slow down the process, right? It means perhaps that the hostile acquirer has a strong incentive to now sit down with the board and negotiate. So we're pushing the board back into the process, but we don't view this as preclusive. And again, there's nothing here that is coercive. There's no alternative deal that's being forced upon the shareholders. And so the response has to be within a range of reason, range of reasonableness. So what does the court consider in deciding whether or not the poison pill falls within a range of reasonableness? What's the first factor they think about? If it's illegal, it's clearly not something that the board can do. Right? But what do they focus on? To decide that, oh yes, this is something that, within a range of reason, the board of directors should be permitted to do. They're looking at the affirmative statutory authority that the board has. They say, look, in looking at the range of reasonableness, of course we're going to assess the nature of the threat, big response, but we're also going to take a look at whether or not the board had the affirmative authority to do what they did. And in this case, they find a number of examples. So the board is authorized to issue rights and options on its own stock. Delaware law expressly provides for it. The stock is generally the issuance of stock, the decision on when to sell stock, the consideration for stock, also expressly something that the board has under the Delaware statute. And of course we have our general provision, 141A, the general provision that says the operations, the board, the business and operations of the company will be under the direction of, subject to the supervision of the board of directors. So it seems as if there's an express statutory basis for the board of directors issuing this poison pill. We talked last week about the anti-destruction provisions, right? The argument by the plaintiff in this case was, well, this is an unusual pill because in fact it doesn't deal with the issuance of the target stock, it deals with the issuance of the acquirer's stock, and there's nothing in the statute that says that the board of company A can authorize stock to be issued for company B. But remember, the court, by analogy, looks at convertible bonds and decides that, notwithstanding the fact that the effect here is the issuance of stock by a different company, the acquirer, it's being done pursuant to a contract with a provision that is customary when there are mergers. Convertible bonds typically have these provisions. There's no reason why a poison pill shouldn't have a similar provision. Okay, court finds that the defensive mechanism is proportionate, range of reasonableness in response to the nature of the threat. Are we done? Case is over, we move on. Is this case done? Well, we know first of all, right, and you actually see it in Moran, once you're finished with intermediate business judgment, what happens? Sorry? Yeah, the burden shifts, right? And you actually see that in Moran. Moran says, now having done the intermediate standard, I'm now going to turn to the business judgment analysis. The burden is now on the plaintiff because of the shifting burden. The burden is now on the plaintiff to demonstrate whether or not the board has the benefit of the business judgment presumption. But you see this actually in Moran. The court is quite explicit. So now having demonstrated they get the heightened unical, they've satisfied the heightened unical standard, the board now gets the business judgment presumption. The plaintiff argues that the board was uninformed, that there was a breach of the duty of care. But the court says, look, largely for the same reasons that I saw the heightened standard being satisfied by the board, I'm also going to reject the plaintiff's claim that there was some sort of duty of care violation. So even though in practice, technically we're dealing with two different standards, in practice very often they get combined together. The same analysis that the court conducts for this heightened standard is also going to apply in looking at the business judgment rule. Okay, now are we done? Case is over. We never worry about poison pills out there. We just move on. Never see we're done. Household has done a good job. They've satisfied the intermediate standard. The plaintiff has failed to demonstrate a care violation, a duty of care violation. Right? The court says, look, for the same reason I saw a reasonable process, lots of questions that satisfy the intermediate standard, I don't see gross negligence in terms of the inquiry for purposes of the duty of care, the business judgment analysis. Poison pill is fine. It meets the standard. Are we done? So thank you very much, household. Let's move on. What do you think? Oh, I know the left side of the room knows the answer. The left side of the room always knows the answer. Is that it? No further inquiry? End of the analysis? Actual actions. What does that mean? Actual actions.
Because
you're going down the right path. Don't let me stop you.
because the bylaw sets the statute to preclude prospective threats. So
The bylaw? The poison pill is not a bylaw provision, right? It could be in the bylaws, but typically not. It's going to be a separate plan.
so they may preclude the prospective threats, but they do not.
Is this preclusive? It's not preclusive. It's not preclusive. Certainly they're trying to, again, they're not precluding everything. Right? Remember, you can get around the poison pill. Right? Proxy fight. So the poison pill is intended not to preclude, not to block all activities. Right? It's simply a defense. It's one way to slow the acquisition down, make the acquirer negotiate with me. Right? So the idea here is to interject the board. Right? You can go ahead and vote me out. That will take time. You can conduct a proxy battle. That will take time, and it may be expensive. But you can also just sit down and negotiate with me. And if you reach a good price, maybe I'll remove the pill. Right? It's a way to get us to sit down and negotiate. Interject the board of directors again. So are we done? Move on to the next case. Oh, what's missing? What's missing? Let me ask you, is there an actual acquisition going on here? No, so what's missing? What is the court saying? Is Unical done, or is there going to be another analysis? Okay, right? They say, look, there is no real threat here. This poison pill was put into place in anticipation of a threat. Now, when there's an actual threat, we will once again revisit the poison pill and any other defenses you have. You might not limit yourself to the poison pill. There may be other defenses, and we'll reassess the poison pill and these defenses against the threat using the exact same Unical analysis. So it will happen again. There will be a second time in the future when there's an actual threat. Right? And at that point, based upon an actual threat, we will look at what the board is analyzing, whether or not in good faith, reasonably, they are assessing the nature of the threat, and whether or not the response is proportionate, not draconian, range of reasonableness, proportion to the nature of the threat. Not just with the poison pill. Maybe there are other defenses they add as well. We don't know. The court doesn't want to simply say the pill is done. We've now approved it. You can just simply have it forever. They say in the future, when there's another acquisition, we will once again assess under the Unical standard whether or not whether or not the poison pill is sufficient, whether it meets the Unocal standard. In practice in Delaware, and we'll see this in air gas, the courts are very reluctant, even though the Unocal and Moran standard suggest that once the pill is adopted, at some future date, there will be a new assessment of the nature of the threat, the nature of the defenses. In practice, Delaware courts are very reluctant to tell a company that they must redeem the pill. Right? We see this in air gas. So even though it's there in Moran, this idea that Unocal will happen a second time, and that the pill plus whatever other defenses will be considered in light of the nature of the hostile threat, because the poison pill is viewed generally as being so effective at forcing the acquirer to increase its price, forcing the acquirer to negotiate with the board, the Delaware courts are really reluctant to step in and say, now get rid of it. Right? It's too substantive. It's too much of a business decision. And so at least to date, and when we get to air gas in a moment, we'll see this, they've been very reluctant to force the poison pill. It's still there. Moran talks about the pill potentially creating a Unocal problem if, given the circumstances of the future offer, there is either no threat or the response is viewed as being beyond a range of reasonableness. But in practice, it's been difficult for the Delaware courts to actually force the redemption of the pill. Okay, so we know the poison pill can be deactivated. Right? That's one of the reasons why it's not preclusive. One of the reasons why we avoid our Blasius issue. It can be taken out through a proxy fight, or you could have a tender offer that conditions the offer itself upon removal of the poison pill. Okay, so you're a creative lawyer. How do you block this from happening? So you know, you now work for Marty Lipton, right? Marty Lipton, Wachtell Lipton developed some of the first poison pills. So Marty Lipton's senior partner turns to you and says, okay, I need your help. Because we know the poison pill is not an absolute defense. It can be removed. Proxy fights, tender offers that are conditioned upon the poison pill being removed. How do we make this thing a little stronger? So one of the ways we've talked about already, right? You combine the poison pill with what? Staggered board. Yeah, we've talked about this already, right? So the poison pill plus the staggered board is a very common defense, right? Remember, the staggered board in Delaware, it's 3 classes. New York, it can be 4. And you can only remove 1 class at a time through the voting process. You cannot remove the entire board unless it's for cause. There has to have been some sort of problem, perhaps an illegality, some sort of egregious conduct. And so the combination of the poison pill plus the board is quite valuable because even with a proxy fight, I can only get rid of 1/3 of the board at a time. Right? That's what we see in air gas. So the combination is a quite powerful defense. Okay, that's one way. What else are you going to do? Be more aggressive. Well, what about this? Let's assume I have a poison pill, and I say the poison pill has rights that are issued. Those rights, like the ordinary pill, can be redeemed, right, by the board of directors. Oh, but in this case, it can only be redeemed by the original board of directors that adopted the pill in the first place. Right? So I'm going to have a poison pill. It's going to be issued. It can be redeemed, but only by the original board. So if you have a proxy fight and get rid of the board of directors, or even part of the board of directors, too bad, you can't redeem the pill. Does that work? No, I hear. Why not? I've just been very creative. Marty Lipton loves me. I'm his star associate. Why can't I do this?
It limits the authority of the new director.
Oh, I love that answer. I've limited the authority of the new directors. Why can't I do that? What case? Well, 144 is the broad grant of authority. 144, right? Broad grant of authority to the board. Right? But why is that a problem? The board signed a contract. Right? You had the original board here, signed a contract. Boards sign contracts all the time. And the contract says that when there's a new board, you can't cancel the contract. What's wrong with that? In this case, there's a Blasius issue. Okay. We find Blasius issues everywhere now, don't we? Why is there a Blasius issue?
It's impossible for a shareholder to get over this.
Bingo, right? So one problem, it's a Blasius issue. Once again, Blasius, right? It's a Blasius issue because we have the board of directors, even if the shareholders vote out the original board, they cannot affect the poison pill. Right? It's limited the franchise, limited their ability through their control over the board to get rid of the old board and have the new board step in to remove the pill. So maybe there's a Blasius issue. Sounds like there could be. What else? Let's not get delayed by poison pills, by Blasius here. What else? 144. You had a good answer. You were so close.
The hierarchy of the
Okay, we've got the hierarchy, right? So we've got 144, we have our charter, we have our bylaws. So in this case, what have we done? We've said that the later board of directors cannot fulfill their obligations, right, to manage the company because the prior board of directors has now limited their ability to fulfill their fiduciary duties. What case? Think sandals. Think shoes. What is my first name? Does anyone know my first name? Charles. Charlestown Boot. Remember Charlestown Boot? Right? Charlestown Boot. CTB. Charlestown Boot, remember, said that you cannot impose fiduciary obligations on the board and cause them to take direction from somebody else who's not a director. Well, that's what we're doing here. We're saying you, the new board of directors, have fiduciary duties, but we're going to limit your ability to exercise those duties by contract based upon a decision by people who are no longer board members. Right? It's Charlestown Boot. It's our hierarchy. 144, broad grant of discretion, combined with the limitation on the ability of the board, consistent with their fiduciary obligations, to satisfy their duties. So Blasius and Charlestown Boot concerns. Okay, so I realize it's a problem. Thank you very much, wise counsel. Now what I'm going to do is I'm going to have by the way, I should tell you, this was referred to as a dead hand pill. So this pill came out, and it was struck down by the courts. For all the reasons we're describing, it was referred to as a dead hand pill. So I realize now that saying that the pill can never be redeemed except by the original board is pretty tough. So instead I'm now going to say 6 months. If you vote in the new board of directors, they cannot redeem the poison pill unless it's the original board. Only the original board can redeem it, but only up to 6 months. 6 months and 1 day, the new board of directors can redeem the pill. Does that cure the problem? It's called a no-hand pill, by the way. So we had a dead hand pill. That means that the pill is there forever unless the original board removes it. Now we have a no-hand pill. It says that for 6 months after you remove the original board, the new board must wait before it can redeem the pill. Is that going to work? 6 months? Can I limit discretion for 6 months? Can I force the new board to act in a manner inconsistent with how they think they should exercise their fiduciary duties for 6 months? In other words, is Charlestown Boot okay for 6 months?
It's a matter of just reasonable.
Really? Charlestown Boot? I can limit the board of directors in the exercise of their discretion, their fiduciary obligations? Can I even do it for 6 days? Right? What are we saying? We're saying the board of directors has broad authority under 144. They have fiduciary duties that are equally broad, consistent with their obligations, their discretion under 144. The charter provisions have to be consistent with the statute. The bylaws consistent with the charter provisions. Can a contract limit any of this? It's a problem, right? It's a problem. So the no-hand pill, same problem. What about Blasius? Can I have a Blasius issue? Can I permit Blasius? Oh, I'm getting rid of your vote, but just for 6 months. Well, the question is going to be, does it rise to the level of a compelling justification? Yeah, what's the compelling justification here? New board of directors, newly elected, wants to exercise their fiduciary duties, get rid of the pill, and now they're being told no.
Maybe they need more information.
Oh, but that's part of their fiduciary duties. Hopefully, if they are exercising their duties, they get lots of information. In fact, one of the reasons they were elected was because the old board wouldn't redeem the pill. Very hard to argue, right, that you're going to satisfy compelling justification. So, for the same reason that the dead hand pill was struck down, no hand pills were struck down as well. Whether you limit it to 6 months or have it for a longer period, you're going to have the same problems. Okay, any questions on Moran? Household finance? Let's do air gas. So you should be aware, the CEO of Airgas is a lawyer. He graduated from Boston University, which is where I used to teach, so I've met him. We've had some chances to talk. He is a mergers and acquisitions lawyer. So he knows M&A law really well. And he is the target in this case of a hostile approach by a competitor called Air Products. It's a 16-month fight. This fight was very big, very highly publicized in the United States. They are both in the industrial, and I think perhaps retail, gas and gaseous products, liquid and gaseous products supply businesses. So 16-month battle. Eventually Air Products loses the bid. So Airgas is defending with what? They are defending with our poison pill and our staggered board, right? So that's their defense. So we know under our Moran analysis that even after the poison pill and the staggered board are approved in the first instance, particularly in the context of the poison pill itself, that there will be a second unical review, taking into account both the pill and the staggered board and whatever other defenses the target has. And again, the court is going to assess, using the unical analysis, whether, given the threat, this particular defense is appropriate. Is it within the range of reasonableness? Has the board satisfied its unical obligations? And one of the questions that really the case focuses on is, having now put this defense into place, the poison pill and the staggered board, which are very powerful, can the board of directors just say no? Go away. We don't want to talk to you. Right? Can they just say no? Or, as the court suggests, just say never. By the way, I don't know if you know, that comes partly from the Reagan era. So Mrs. Reagan, President Reagan's wife, one of her big social sort of charitable activities was no drugs for children. And her slogan was, just say no to drugs. And so it's the just say no defense. In this case, just say no to hostile acquisitions. Or perhaps just say never. And so that's what the court is wrestling with, right? At what point should the court, consistent with unical, as applied in the Moran case, looking at it a second time now, this poison pill and the staggered board, in light of the nature of the threat, at what point can the court step in and force the board to redeem the pill? How long can the board just say no? Go away, we're not going to work with you, we're simply going to defend. So in this case, we have something special about Airgas something more than simply the poison pill and the staggered board. Two very special provisions that actually weaken the poison pill and the staggered board. So it makes this case a little less common, and ultimately that's the important part about this case, right? It's a little less common than what you might see in the case of just a poison pill and just a staggered board. So what was there were two unusual provisions here. Do you recall what they were? Special meetings. Special meetings, right? Remember, right, if you're going to try to elect a part of the new board of directors, you can either wait for the annual meeting or you can call a special meeting. And the special meeting is typically either going to be provided for in the bylaws. It might permit a shareholder or a group of shareholders to call the meeting, but very often it's simply limited to the board of directors. Is the board of directors of a target going to call a special meeting to benefit the acquirer? No. But in this case, they have a special provision for special meetings. What do they say? 1/3, right? You can call a special meeting if 33% of the shareholders decide to call a special meeting. Okay, so if we want to vote and you have 1/3 of the shareholders that support you, you don't have to do a consent process. We talked about it in the context of Blasius. You can simply wait until the next annual meeting, or if you have a 1/3 vote of the shareholders, you can call your own special meeting to decide what it is you're going to do. Vote out the board, change other provisions that you think are inconsistent with what the shareholders want. And what was the other more important provision? 2/3? Okay, so you can remove the board. So normally, you cannot remove the directors on a staggered board of directors unless there is cause. But remember, there's an exception. It says, unless the charter provides otherwise. And in this case, the Airgas charter says you can remove without cause if you have a vote of 2/3 of the shareholders. Okay, so they've weakened the staggered board by permitting, inconsistent with what would otherwise be provided simply in the statute, they've now provided in the charter, notwithstanding the default rule, this idea that with 2/3 of the shareholders you can actually get rid of the board of directors without cause. So that makes it weaker than the normal protection. And they're also saying you can call a meeting with a third of the shareholders. You can call a meeting. Okay, so based upon this, we have an election that takes place during this fight between Air Products and Airgas. And what happens during this election? Air Products puts up their own nominees, right? They say, look, we're going to put up our own nominees against the Airgas nominees. And who wins? Who wins? Sorry? Air Products wins. Okay, Air Products wins. So the old Airgas guys are gone. And now you have the new Air Products nominees. So now they have 1/3 of the board. When Air Products nominates them, does it say, look, these guys are Air Products guys? These guys are there to support us? What do they say? They're there for the company. They're independent. They're neutral. Vote for these guys because they are neutral. They are there to assess on behalf of all the shareholders whether or not what Airgas says is the case. Right? Airgas had been arguing that the Air Products price was too low. Whether or not that's in fact the case. So they're independent nominees with no bias. Right? And Air Products says this in the proxy materials. It says, if you give us your proxy to vote in these nominees, you're voting for someone who's neutral. Not an Air Products guy, but someone who will be able to independently, on their own, assess the nature of the Airgas statements, whether or not the price that Air Products is offering is in fact too low. And then what happens? Sorry?
They are neutral.
Yeah, they are neutral, right? They say, you know what?
They're going to be the other director.
Yeah, the $70 price that Air Products was offering, you know what? They were right. It is too low. Right? In fact, they actually become more aggressive in saying we should resist at all costs this Air Products offer than the original Airgas directors. Right? It's like they're newly converted. And it's based upon confidential information, internal information, as well as information from advisors that the board at Airgas receives. It's the sort of information that Airgas doesn't want to make completely public. It's confidential information. It explains the way they run the business. What they're really arguing is, remember this is kind of during the financial crisis period, what they're really arguing is that Airgas stock is hurt much more when the market is down, but it also rebounds quickly, but late. Right? So the market was generally down. Airgas is hurt more than the market generally is. It will be delayed in rebounding, but when it does rebound, it rebounds very high. That's their argument. And they show this based upon their internal financials, their internal results. Again, information that's confidential. It also includes projections, where they think the company will be in the future, not information they can give to the general public. But these new nominees get all this information, and they say, oh my goodness, $70 is way too low. By the way, last week I told you, Airgas closed at $95.95. This last week they closed at $97.20. So yes, $70 was too low, even though it was a substantial premium over the market price prior to the Air Products fight. Okay, so we're going to assess this takeover defense, the combination of the staggered board and the poison pill, using our Unical standard. And the court accepts, primarily based upon what these three nominees, these new guys, are saying, that the price is very likely low. There's a little skepticism in the opinion, and part of the reason is because it was a substantial premium over the Airgas price. There were a number of arbitrageurs. We talked about ARBs last week. Those who are buying and selling based upon the likelihood of a deal taking place. A number of arbitrageurs had bought significant blocks of Airgas stock on the expectation that the deal would happen and they would make a huge profit in a very short period. So the court's a little skeptical about whether $70 is not sufficient because it was so much higher than what the market price was. But it tends to be persuaded by these independent nominees, based upon their review and their assessment, $70 is too low. That yes, there is a threat, right? And the threat here is that the price that's being offered is not reflective of the true value of the company. You might think of it as the shareholders not knowing, right? They don't have all the access to this information. Not knowing the actual value of the company, may accept a price that is too low than the real value that someone with more information might assign to the stock. Okay, so then the question is the nature of the response. Is it coercive? No, right? They're simply maintaining the long-term plan. Remember, when we're talking about coercive, it's forcing the shareholders to take another deal. That's not happening here. The board is saying, hey, what we are doing is a good thing for the company. The long-term value for this company is quite good. Our plans are good. We are just simply staying and doing what we said we were doing. So it's not coercive. Is it preclusive? That's the big question, right? Is it preclusive? So the court says, look, it's pretty clear that control over Airgas, realistically, is not attainable in the short term. And the reason it's not attainable is because it's going to take time to vote out the board of directors. So it's going to take at least another 8 months before the directors will be up again for election. And it means that if you are Air Products and you wish to take control of this company, you're going to have to continue to fight over the next 8 months before you get enough directors in order to be able to remove the poison pill. And he says, look, even though it's theoretically possible to do, in terms of sort of common sense, a common sense idea of what is or isn't attainable. It's just never been done. No one will stick around for that period of time in order to remove another class of directors. It's just too risky. It's too expensive. Right? Who knows whether you will win? And let's assume you try to take control in the meantime. Perhaps you do a tender offer. It means that you own a company where some portion of the board is against you. So either you have to continue fighting for the board simply through a proxy process, or you end up controlling a company through actual ownership of the stock, but again with a board that you cannot remove in the ordinary course. So as a practical matter, no historical examples where an insurgent has actually stuck around for 8 months. But in this case there's something special. Remember, with 2/3 of the vote, you can get rid of the entire board of directors. Right? This is a little unusual. It's different than the normal staggered board. So why doesn't that work? Right? Again, the court says as a practical matter, no one ever can get a 2/3 vote. It's never happened. So does that mean that it's going to be preclusive? Yes, okay, you could go ahead and get rid of the board. All right? Everyday sense, in the everyday sort of common sense of the idea of preclusive, the poison pill, the board of directors, seems to block the ability of anyone to take control of the company. Lack of historical examples of a proxy fight being sustained over this 8-month period, of someone spending the time and the effort to take control, realistically of getting a 2/3 vote. Does that mean that it's preclusive? Why not in this case?
We just need to wait another 8 months and they can get the majority of it.
They say, look, preclusive means that we're blocking you. That's not happening in this case. Right? You could, in fact, wait around for 8 months and take control of the board of directors. What else could you do, though? The court makes some very funny comments about this. What else could you do that would make it not preclusive? Well, you know you can get a 2/3 vote. It's never happened before. But what's the answer to that? This is the quote on page 1286. I don't know if you recognized how sarcastic he was being when he says this. He says, the following final tautological insight by the expert just about sums up the usefulness of this particular day in the life of a trial judge. He's basically saying this was a useless day in his life. Question, so what is a sufficiently appealing offer? Answer, an offer that will garner 67% of the vote, I suppose. So he's got experts there at trial. And he's saying to them, tell me what a good price is. Right, you're saying $70, is that a good price? Well, these guys say it's not a good price. So what is a good price? Right, what's going to be a sufficient price to be appealing to shareholders, to reflect what the value of the company should be, that the board of directors should take into account in deciding whether or not there continues to be a threat? And the response is one that he clearly is not comfortable giving a number. He says it's going to be a price that's high enough that gets 2/3 of the shareholders supporting it. Why? Because once you have 2/3 of the shareholders, you can vote out the board of directors. It's very circular, right? So he's not going to give you a price. He says whatever the price is, you'll be able to vote out 2/3 of the directors. So, okay, you could wait around 8 months. Or what else could you do? By the way, this was an expert for Air Products, too. So you could wait around for 8 months, or what else could you do? Raise the price, right? He's saying, look, it's clear from Air Products' own expert, right? He's using this testimony that if you would raise the price high enough, you could have also done this deal. So the deal's not being blocked. We're simply delaying it from happening. So it's theoretically, and really even realistically possible. Realistic in the sense that you could do it. We're not blocking you from actually doing this takeover. And you could also raise the price. And he takes a lot of comfort again from the fact that the $70 price has been rejected by the Air Products nominees. And no one is prepared to give him a price, but he knows that if the price is high enough, he's going to get support from enough shareholders to be able to remove the board. Once the board is gone, you can remove the poison pill and the deal will go forward. So he said, even though in common sense terms you might view this as being preclusive, control is realistically attainable here, either over a period of time or through an increase in price, and as a result, it's not going to be preclusive. Right? I don't view this as preclusive. But the key here is, right, he distinguishes this from a more common fact pattern. Right? This is the analysis based off of the Yucaipa case towards the end on page 1289. He says, look, he's not addressing a different scenario. So in this case, I'm not going to say it's preclusive. I'm not going to order the company to remove the poison pill. But what of the case where you have a staggered board? Perhaps you have directors who win from the hostile acquirer, 1/3 of the board. Presumably, unlike the Air Products directors, they don't support the target's board. So you have a change in shareholder sentiment that at least for this 1/3 of the board favors the new directors. And you have a poison pill without the ability to remove the board. Right? So the 2/3 provision, the ability to remove the board with a sufficient vote from the shareholders, let's assume that doesn't exist. And you have a staggered board where 1/3 of the directors are going to be elected by the new acquirer, right? The dissenting shareholders. He said, in that case, should we force the poison pill to be removed? He doesn't really answer it. He suggests that maybe at that point, using the unical analysis, maybe at that point we do have to step in and force the poison pill to be removed. Not based upon an assessment of price, right? The court isn't in the position to assess what the price is, but based upon the fact that these new directors who represent the acquirer have now been voted in by shareholders who appear to be unhappy with the existing board and with the position they're taking to the acquisition. Right? So maybe in that case, again, different set of facts from here, maybe in that case, again, he's just speculating, the court should step in and remove the poison pill. Okay, so, not draconian, back to our air gas case, but there has to be a range of reasonableness in terms of the response. In this case, we have, what type of directors do we have? A majority of what? Sorry? Majority of independent directors again, right? This is a majority of independent directors, not dispositive, but it means that the court's going to pay a lot more, is going to defer a lot more to their assessment of the nature of the threat. And more importantly, we see 1/3 of the directors who were put up by Air Products actually agreeing that $70 is too low. So this is a big threat, right? It's a big threat based upon information the shareholders don't have. And so the response is proportionate to the threat. And in this case, given the high nature of the threat, given the fact that 1/3 of the directors, the Air Products directors, now support the air gas position, he finds the response to be reasonable as well. Right? So that's what's going on in this case. Fun case? Okay, why don't we take our 10-minute break and we will pick up with Revlon.